Randy Barnett, welcome back to Dad Saves America.
Well, it's great to see you virtually this time, although I prefer if we met in Las Vegas again. I think that would be more fun.
For sure, especially in the hotel, not outside. You've got two of your books here, and before we started rolling, we were joking that I was pulling a Jiminy Glick. I was like, "Oh, your book here. I haven't read your book. I'm sure it's wonderful." Felony Review. It's like straddling the two worlds of Randy Barnett, I feel like, in a way, isn't it, this title? So let's start here. What does Felony Review mean, Randy?
Felony Review is a unit that I was assigned to for 9 months during my 4 years serving as an assistant state's attorney in Cook County. Assistant state's attorney is what other people call a DA, an assistant district attorney elsewhere in the country. It's a criminal prosecutor in Chicago. And there's this unit, a specialized unit, that was created because an agreement was reached between the Chicago Police Department and the Cook County State's Attorney's Office that no felony charges could be placed by the Chicago Police against an individual unless a Cook County State's Attorney signed off on it, approved it. And because of that arrangement, a full-time unit of assistant state's attorneys had to be formed, a 24/7 unit that was stationed in the police stations themselves. They didn't go to court. They went to offices that were in area headquarters, and they would be called to the district police station or the area headquarters where a suspect was in custody or charges were being sought. They would interview the witnesses. They would talk to the cops. If possible, they would talk to the suspect, get a statement from the suspect, possible confession if the guy was guilty. And then on the basis of weighing all the evidence, they would decide whether felony charges should be brought. This was real review. It was not fake review. We had an approval rate of about 60%, which meant we rejected 40%. Individual state's attorneys' approval rates were monitored by our supervisors. We kept logbooks, and we had to turn those logbooks in weekly. And then our stats were compiled to see what our approval rate was. And our job was to ensure that only strong cases made it past the charging phase and into the trial courts, into the criminal justice system. So it was the original Innocence Project. We actually freed people in the police station for want of evidence or other reasons that might relate to the weakness of the case.
All right, I'll keep this quick. If you like what you're hearing and want to hear more, don't forget to hit that like button and subscribe to the channel so you won't miss our new content as it comes out every week. And now, back to the conversation. As I was, preparing, one of the things that immediately came to mind is, in a way, you were a kind of like Harvey Dent character in 70s, 80s Chicago. Sort of, right? I mean, that's a pretty tough time to be in law enforcement in a city like Chicago or New York. So just set the stage for what was going on. It's like we almost take for granted, even though crime has upticked in more recent years, just how safe our cities, at least in New York, let's say, because I know Chicago is still kind of a disaster. But what was it like?
Chicago got much better before it got worse again. And how bad it is, I can't really speak to. How bad it is right now, I can't really speak to, because I left Chicago in 1993 to move to Boston to join the faculty of Boston University. And then from there, I went to Georgetown, where I'm a law professor there. In 2006, I went to D.C. I go back to visit, but I don't have my finger on the pulse of how bad crime is now. But it was pretty bad when we were there, and we were part of cleaning it up. I was actually, when I joined the state's attorney's office, I moved up through the ranks real quick, very much more quickly than you can today, partly because under the Nixon administration's war on crime, they've poured a lot of federal money into local law enforcement. That meant opening new courts in the Chicago area. That meant hiring new state's attorneys, new public defenders, new judges to staff those courts. And because of that, they sucked in a lot of people. I just happened to come in at that time and therefore was able to move from misdemeanor branch courts, is where I started, through felony review, through the preliminary hearing course, and then spent 2 years as a felony trial assistant trying murders, rapes, and armed robberies to juries. And felony review, the book Felony Review, isn't just about my time as a felony review assistant, but it's the entire process of what it is like to be a big city prosecutor from the beginning, when you don't know anything and you're really overwhelmed by everything, to the end when I was a first chair in a felony trial courtroom at the criminal courts building at 26 in California, deciding how we were going to manage manage a murder prosecution and getting up in front of a jury and asking them to find a particular man or a particular guy guilty. It was an amazing time to be a prosecutor. I think pretty much any time is an amazing time to be a prosecutor, but it was a particularly good one for the reasons I just said. The other thing that was singular about Cook County in those days was how corrupt the judiciary was. And the book is also a story. It's a story of all the true crime cases that I was involved with, both in the police stations and in the courtroom. It's also a story about doing battle with a corrupt judiciary who were taking and fixing cases for money, and how we dealt with that as honest prosecutors in a corrupt system. Now, I want to make clear that not every judge was on the take. There were a lot of honest judges, and primarily the corruption took place at the misdemeanor court level, where you could do a high volume of corrupt cases for low amounts of money and stay off the radar. Generally speaking, big cases, felony cases, were completely on the square. They were not fixed. But nevertheless, it was the overall corruption of the system and the immunity that everyone in the system felt that they were nothing was ever going to happen to them as a result of this corruption that fed the atmosphere that I was immersed in. But as it turns out, something happened, which I talk about at the end of the book. There's a big reveal. Something was going on when I was a prosecutor that we didn't know about, and that ended up enabling me to name names in this book. I actually name the names of the corrupt judges and the corrupt lawyers, and I can do that because of subsequent events.
I want to lay some foundation because one of the things that is interesting about your experience, because you go from duking it out in Chicago all the way up to the Supreme Court over the course of your career and doing battle with Obamacare. And you have your other book here, which we'll talk about the 14th Amendment and the original meaning of the 14th Amendment, which is coming up in the courts. So we're going to come to that later. We've gone through these, it seems like some waves culturally, politically, about how to deal with crime. Help me understand how you see those waves of crime in American cities, especially like if you start the clock in 1950. So you're before the kind of 60s wave of crime and then the subsequent crackdown, etc. Like how should Americans understand what has happened to crime, prosecution, and the politics of fighting crime?
Well, there always has been crime. There always will be crime. There always needs to be. We always need to do something about it. And every society is the same way, and every society does something about it. And I was a child in the 50s. I didn't personally experience the criminal justice system until I was older, and that would be in the late 60s and 70s. I became a prosecutor, to be clear. From 77 to 81 is when I was a prosecutor, which meant I went to law school from 74 to 77. But there was a huge influx or increase in crime that took place in the 60s. It was a great boom of crime. And then there was, a lot of police response to that. But at the same time, there was also the rise of the civil rights movement and reform in criminal justice itself, which took the form of protecting the rights of the innocent by means of the example everybody knows about are the Miranda warnings that you have to give as a result of a Supreme Court ruling. And I actually think, unlike others on the right, I actually think that what the Warren Court was doing from a criminal procedure standpoint was pretty healthy. I mean, whether or not they really had the authority to do it is a separate question than whether it was a good thing that they did it on balance. And I think it was a very good thing, because by the time I reached the felony trial court, but by the time I reached the criminal justice system in the late 70s, I saw very little evidence, almost no evidence of police abuse of suspects. Now, I'm not saying it never happened. We know it happens. The question is how prevalent it was. And the other question is, how normal is it? How normalized is it? And I think there's every reason to think that some coercive interrogation techniques were considered normal. And if you didn't engage in that kind of techniques, you were not kind of a good cop. I think what the Warren Court reforms put in place was an internal consciousness on the part of police that there were limits to what they could do, and the suspects did have their rights. One of the things I do in felony review is I try to draw lessons from my experience. I stop the storytelling and I say, well, what does that tell us? Yeah. And one of the issues that I deal with as a lesson is, well, were the Miranda warnings a good thing or a bad thing? There's a lot of people that complain about it because if you don't give them properly, and there was a case I confess where I did not give them properly, and I tell the whole story of how I messed up and how we fixed it. But if you don't give them properly, the guilty guy goes free. Isn't that terrible? When in fact, I think the primary function of the Miranda rights were not to tell a suspect, not just for a suspect knew what his rights were. Generally speaking, if they'd been to the penitentiary, they knew what their rights were. If they hadn't been to the penitentiary, telling them what their rights were didn't make much difference to them. But what it really did is it created a psychological state in the officer who had to give those rights day in, day out, countless times a day. They say, you have a right to remain silent. You have a right to have an attorney. They have to say those things. That means they start to believe those things. And the good cops who don't want to coerce suspects, they get bolstered by the very things everybody has to say. That leaves the bad cops in, sort of the exception as opposed to the rule, where it probably had been the rule. By the time I was there, it was by far and away the exception. That's one of the good news stories of my book.
All right, here's a quick word from the sponsor of this video, Van Man. Have you ever actually read what's in your toothpaste? Fluoride, SLS, glycerin, foaming agents. It's a chemical cocktail you're putting in your mouth twice a day. And frankly, Big Toothpaste has been selling you the same toxic formula for decades, which is why the Van Man Company is changing that with their miracle tooth powder. Here it is. I use it. It is quite good. People, including myself, are ditching traditional toothpaste by the thousands. The reason why I use it is because if I so much as nick my mouth, I get a horrible canker sore that lasts for weeks, and I have found that traditional toothpaste makes that much, much worse. But I get a lot less of that with this Van Man powder. Van Man's tooth powder uses real grass-fed cattle bone hydroxyapatite. I practiced that. It is actually the same mineral structure as your real teeth to remineralize and strengthen enamel naturally. And if you're a vegetarian, you should at least know that they're making full use of the animal. This is a good thing. We have to do something with these bones. Most hydroxyapatite on the market is synthetic. Van Man uses the real thing from grass-fed cattle, loaded with virtually all the minerals needed to rebuild tooth structure. Zero fluoride, zero SLS, zero foaming agents, and it's completely edible because anything you're going to put in your mouth should be. Users report whiter teeth, less plaque, plus you wake up without that gross film in your mouth because there's no foaming agents destroying your natural saliva production. Make the switch to real oral care. Go to vanman.shop/dad and use code DAD, D-A-D, for 15% off your first order. That's vanman.shop/dad and use code DAD for 15% off your first order. Van Man, real ingredients, no exceptions. And now back to the video. You referenced the Warren Court for people, including myself, who aren't really familiar with what how consequential what the Warren Court means. What are you referring to?
The name Warren is Chief Justice Earl Warren. Chief Justice Earl Warren had been governor of the state of California. He was appointed by Dwight Eisenhower to be Chief Justice of the Supreme Court, succeeding Chief Justice Vinson. His first big move as Chief Justice was to get the court together and decide Brown versus Board of Education unanimously. Something that had been held over for re-argument before he became Chief Justice. When he joined the court, he ensured that he got everybody together and there was a unanimous judgment that said that race discrimination in public education is unconstitutional. So that was his first big splash. But he went on to do his court went on to do a bunch of other things, some of them good, some of them not so good. In the case of the criminal procedure reforms, I think they were, as I say, I think they were good. What really makes the Warren Court objectionable is not so much the results they reached, but how they reached them. And they largely reached them by a kind of loosey-goosey, seat of their pants, this seems right, so it's constitutional, this seems wrong, so it's unconstitutional approach that just put aside the text of the Constitution and its original meaning. And the modern conservative legal movement, the modern originalist movement, was actually arose in response to that approach to constitutional interpretation, not so much to the results, but to the way those results were reached, which allows a court to reach any result they might want to reach. And that extends the power of the judiciary beyond what it should be. So the Warren Court gets credit, I think, for a number of things that it did that were good, but it also gets the blame for sort of undermining our commitment to a written constitution, which fortunately has been revived by the modern originalist movement.
Well, in our last conversation, which I'll encourage people to check out, and we'll put a link to below, we talked about this because you are one of the leading voices, sort of intellects, public intellectuals, legal scholars of originalism. So just as a reminder, what is originalism?
Okay, I can summarize originalism in one sentence. It is that the meaning of the Constitution should remain the same until it's properly changed by amendment. Let me say that again, because it's a very controversial position, and I'm sure many of you listening can't imagine why it would be, but I'm going to say it again. This is all it is. The meaning of the Constitution should remain the same until it's properly changed by amendment. And by amendment is the Article 5 process in the Constitution that says how it should be changed. So what it means is that judges should not be changing the meaning of the Constitution to something that's better. Legislators shouldn't. The president shouldn't. Those are all the people that are supposed to be governed by the Constitution. So here's another thing that sort of explains why originalism is important, and that is the Constitution is not the law that governs us. The Constitution is the law that governs those who govern us. And those who govern us should no more be able to unilaterally on their own change the law that's supposed to govern them from its original meaning than we, the people, can change the laws they make to govern us without going through the legislative process. So the written Constitution is a way to subject our government to law. And that only works if it has a fixed meaning, and that fixed meaning can't be changed by those it's supposed to govern. That's originalism.
I'm going to come back to these broader constitutional issues, but to linger on crime and your experience in Chicago, how should I think about, and how should people who've heard about, let's say, George Soros DAs, right? So this is sort of like a political phrase. There's the George Soros DAs. What is that movement? First of all, from your perspective, because I know you're a very reasonable person. You know, is there a thing for real, George Soros DAs? What does that mean? What are they doing that you weren't doing?
My nickname is Reasonable Randy. And so you're right. I'm reasonable. But let me just tell you, George Soros prosecutors are real and they're dangerous. And they go against all the assumptions on which our criminal justice system is based. Now, let me go back to when I was a prosecutor. When I was a prosecutor in Chicago, I worked for a Republican, an elected Republican state's attorney. State's attorney of Cook County was an elected Republican named Bernard Carey, former FBI agent, ran as a reform candidate, beat the Democrat in Cook County, became a reform prosecutor, served for 2 terms. I was there for the last 3 years of his second term. He was defeated and replaced by a Democrat, Richard Daley, who was the Mayor Boss Daley's son, who ultimately went on to be mayor of Chicago. So we went from a Republican to a Democrat. Now, frankly, the Republican managed his office in a non-political fashion. Most of my colleagues were probably Democrats, actually. Didn't matter what party you belonged to. I could probably have not gotten a job at a Democrat state's attorney's office. I would not have had the political clout. I would not have had a ward committeeman to write me a letter. And so I was able to be hired without having a partisan identification out of merit, which was great. But when our boss was defeated by the Democrat, by Rich Daley of all people, Boss Daley's son, we were deathly afraid that the state's attorney's office would become corrupt and self-dealing and full of political patronage, the way all the other Cook County institutions and Chicago institutions already were. We were sort of an island, an oasis in a sea of corruption. But guess what? That's not what happened. When Rich Daley came in to be prosecutor, he was as good a prosecutor, as good a state's attorney as Bernie Daley was, as Bernard Carey was. I'm sorry. We had Democrats who had lobbied for, who had worked for his reelection, who we didn't like internally. When a new state's attorney comes in, all the supervisors leave because he gets to appoint his new supervisors. So all the supervisors I worked for, who were great, they left, although some of them probably had risen to their level of incompetence. This is always the case in any organization. Well, who did Rich Daley replace him with? Well, he went and he picked among my colleagues, more senior people, the new supervisors. They were all the good ones. And he didn't pick any of the politicos that we feared, given their tightness to the campaign. They'd pick him. He ended up being a very good prosecutor because it turns out fighting crime is nonpartisan, or at least it used to be. And so it didn't matter as much whether a Democrat was a local elected prosecutor or Republican. It didn't even matter in Chicago, of all places, much less the rest of the country. George Soros and his money has changed that. He discovered something with respect to prosecutors, and he's also discovered it with respect to other offices, and that if you go way down ballot, if you go all the way down to the county prosecutor level, there's very little money being spent on campaigns. It doesn't take much to tip the balance in favor of the guy you want. And that's what he decided to do. He invested in left-wing prosecutors who actually don't believe in prosecuting crime. They believe in whatever they believe in, and this is not a program about what they believe in. But you see in Chicago, where there was a Soros prosecutor, and I talk about her a bit at the end of the book, replaced by a Democrat who is not a Soros prosecutor. So we have hope that Chicago is going to pull out of its tailspin. But she, the prosecutor in Chicago, lost a lot of her supervisors who said, I got into this business to prosecute crime, and she's not letting us. That's Kim Fox, is the person that some people might recognize the name. And that's been happening throughout the country, in San Francisco and elsewhere. The prosecutor in San Francisco got withdrawn because he wouldn't prosecute crime, replaced by somebody who might. So until recently, prosecution was more or less nonpartisan. Or bipartisan, and it's no longer the case, and it's really, really dangerous. Because if you don't have a prosecutor doing the prosecutor's job, doing the job I did, the whole system breaks down.
One of the things that I know you reference is this the issue of evidence and what might make evidence inadmissible, and we all see this in like Law and Order, right? and the various types of shows and films like this, where you're trying to make sure that you don't what's being done can not be struck down in court, like you were referencing. But you have an interesting take on this. So lay out sort of what does it take for police work to make its way into the court and survive? And what are some of these things that you've identified as being maybe even useful, but sort of no longer serving their intention?
Well, I don't think this has changed very much. The difference between prosecutors and defense attorneys are prosecutors have the burden of proof, which means they have to prove something is true. They have to prove something. And so the job of the prosecutor is to prove something. And so the question before every prosecutor's mind is, how do I prove this? Not what happened. How do I prove what happened? Assuming we know what happened. How do I prove it? Because if I can't prove it, it doesn't exist. A defense attorney's mindset normally is to knock down what the prosecutor's doing. So the prosecutor's kind of got this positive function of building something, and the defense attorney's got a deconstructive function of deconstructing what the prosecutor has built. And so there's two different mindsets. It's one of the reasons why, though I was inspired to become a prosecutor by a television show that came on when I was 10 years old called The Defenders, which was about a father and son criminal defense team in New York City. It was a very gritty, very realistic, filmed on location in New York in black and white. It was really inspired me to be a lawyer. But why I ended up not being a defense attorney but being a prosecutor is because, generally speaking, my personality is to build things, build theories, build arguments, build stuff. It's not to tear down or be critical of what other people have built, which is a really standard academic position to have. You're a critic, right? So I and the other thing, the difference between the prosecution and defense is the defense attorney's ethical duty is to zealously pursue the interest of his or her client. And if they don't do that, just as if we don't have prosecutors doing their job, the system collapses. If we don't have defense attorneys doing that job, the system also collapses in ways that have happened, frequently in our history. The prosecutor's ethical duty is different. It's not symmetrical. The prosecutor's duty is not to win the case. The prosecutor's duty is to do justice. And if that means bringing a charge and getting a conviction, or if it means dropping a charge because evidence is lacking, or letting people go because they're innocent altogether, that's what a prosecutor is ethically bound to do. Now, prosecutors don't always do that, but that's what they're supposed to do. And I was more comfortable both with the building function and with the doing justice function than I was with the role that defense attorneys play. This has not changed. And so, again, when I was doing in felony review in the middle of the night in a police station, was thinking, what will a defense attorney make of this file? Because, first of all, we have an adversary system. We have to anticipate there will be a competent defense lawyer who gets to see these charges eventually after they're brought. So what are they going to do with this file? How will they characterize what happened here? And is there anything I can do in the police station before we even bring charges to negate this move that they make? And I tell the story of several times in which I was able to make a move in the police station that completely negated what I anticipated the defense was going to argue later on down the road.
What is like a really helpful one from the book, from those examples that, would help people understand what this really is like?
Well, the book opens with me in the middle of the night about to take a confession from a young man who had, along with 3 of his fellow gang members, had brutally stabbed to death three young men who had driven into Chicago from the suburbs to buy marijuana and said the wrong thing to the wrong people and ultimately ended up in an alley with these Latin kings who brought them into the car one at a time and stabbed them to death, bringing the first one in, stabbing him to death, pushing the second one in over on the top of the first one, stabbing him to death. They did that to all 3 of these young men, these 4 guys. And so I was in the police station in the middle of the night taking a full, detailed confession from one of the perpetrators, from one of the guys who did the stabbing. And one of the reasons why I know so many details about exactly what happened in that alley is because he's the one that told me. Because there were no survivors. They couldn't tell me, but I heard it from his mouth, and it's in a written court-reported statement that I talk about in felony review. You get to hear or read some of the grisly details. But what I thought was a likely defense move to make is, okay, this particular guy, Juan Caballero, he was, I think, 19 or 20 years old, had a relatively clean adult record, maybe 1 misdemeanor or something. He was not a hardened criminal. He looked good. I mean, he was a handsome kid, looked clean cut. And I could just see the defense attorney saying, you know what, this guy got swept up in all the emotion of his 3 other guys. Or they could say he was afraid of the 3 other guys. And so he had to go along with the 3 other guys because, look, he's not a bad guy. Look at him, ladies and gentlemen. Is that a guy that deserves to be punished? Is that whatever? I could imagine that was going to be the defense because I had a confession. It was a dead bang. He did it. Now, how are they going to get him out of that? That's what I anticipated. So after the confession was read by him, initial every page, make corrections if he wanted to make any corrections, signed by him. It was all done. This process takes 6-7 hours between my first conversation and finally signing on the dotted line. I turned to him and I said, Juan, if you had it to do all over again, would you do it again? His response was, well, if it was a sure thing. And I said, well, there ain't no such thing as a sure thing. And he said, well, a lot of kings have killed people without getting caught, meaning Latin kings. And I said, I know, but you got caught. Would you do it again? And he said, well, I'd have killed the first one, Michael, for sure. I don't know about the other 2. Michael was the one that was lipping off. Michael was the one that was bragging about all the contacts they had with the Latin eagles, not realizing he was talking to the Latin kings. And when they heard that, they went from, we don't have any marijuana to sell you to, oh, yeah, we do have marijuana. Come with us. And then they killed him for all this. And he says, I'd have killed Michael for sure. I don't know about the other 2. Well, let me just tell you, down the road, when that case went to trial, I had to turn to the jury and tell the jury from the witness stand, because I was not the prosecutor in that case. I was a witness to the confession. And as I was relating the confession, I turned to the jury and I told the jury what Juan Caballero had said. And they came back with guilty and they came back with the death penalty. And the only reason he's not still on death row or hadn't been executed is that a corrupt Illinois governor decided to commute all the death row sentences in order to curry favor with the media in Chicago. Didn't do him any good. He ultimately ended up getting convicted of corruption and going to jail.
Is this?
But he ended up.
Which one is this? Is this Milosevic, or is it somebody earlier than? I guess it'd be somebody earlier than him.
Yeah, it was, and I had that name in my head as I was telling you the story, and it just popped out of my head. It'll come back. It'll come back to me what the name of that governor was. But at any rate, Juan Caballero is still on death row. I mean, he's still serving life imprisonment without parole, which is what happened when his death penalty got commuted. But getting back to what you asked me. What I did is, anticipating what the defense was going to do, I made my move in the police station by asking him this question, got that answer, wrote the answer down, and that was that case went up on appeal, and that was testimony as to whether there was whether this death penalty verdict had been justified. And the Supreme Court of Illinois actually quoted the dialogue between me and Juan Caballero to uphold the conviction on appeal.
That's a really. When I think about that, you're having to be highly strategic in an incredibly volatile environment with literally life and death and blood and murder at all hours of the night. I mean, that's intense. That's a high risk and also like a high error prone environment. Like to have to think that way, to say, I need to get this.
You're young and you're inexperienced. In 78, when I did that, I would have been 26 years old. I had been to law school. I'd been to 1 year out of law school when I was working the misdemeanor branch courts before I went on felony review. I'd never been a felony trial assistant, although, frankly, in my training as a law student, both at Harvard Law School, in the Middlesex County DA's office, as well as in the Cook County State's Attorney's office as a student intern, I had actually prosecuted cases, and I'd even participated in felony trials. But still, I was very inexperienced. And I'm supposed to see the world the way an experienced trial assistant would see it in the middle of the night. And, we did the best we could. The thing that we dreaded the most after we had proved a case and sent it upstairs is to get an angry phone call from an assistant state's attorney who was the trial assistant saying, "Why did you give me this piece of garbage? Why did you do this?" That was the phone call we never wanted to have. And one reason we didn't want to have is because we wanted to make it to the felony trial courts, and we didn't want something like this to be held against us. And so our job was to make it a strong case or not send it along at all.
Why go into this line of work? I think a lot about, of all the kind of career opportunities our kids face. My son's 21. He's actually interning at the police department, actually. So this is sort of very personally on my mind. Make a case for going into this line of work.
Well, it wasn't for the money. Starting salary as a state's attorney was $15,600, which, got to take into account what dollars were worth back then. But a starting salary at a law firm at those days was $35,000. So it was not to make the money. It was not for the prestige or status, because being a county prosecutor is a very low status job, especially if you're from Harvard Law School and your fellow classmates are asking you whether you think they would say to me, well, maybe that's noble, but don't you think you're going to be wasting your degree? That was the words they used, wasting your degree, your Harvard Law degree, to go be a county prosecutor. And the only answer I can give you is that it's what has motivated me from the time I watched The Defenders when I was 10 years old to this very day, as I'm writing a book on libertarianism, right now, is justice. Justice has been the unifying factor, the unifying concept that unifies everything that I've ever done. Now, when I was in the criminal justice system, I was getting justice retail, case by case, trying to make sure justice happened, injustice was avoided. That was my job. That's what made it so gratifying. That's what made it such a great job, so satisfying. That plus the drama. It was better than TV. We can come back to that. It was better than TV. But when I left the prosecutor's office to become a law professor, initially teaching contract law and eventually teaching constitutional law, my commitment was the same. It was to do justice, only now is to understand better what justice is, and hopefully affect justice on a more wholesale scale than you can case by case. Because when you're in the system, case by case, you can't change the system. You have to work within the system to make it work as best it can. From outside the system, as an academic, I can advocate for reform or change, which is, for example, what I've done advocating for return to the original meaning of the Constitution.
there's a theme of trying to stay clean in a corrupt system. Talk about that. Talk about one of the things that I think about, I have several lawyers in my family. When I think about lawyers in general, I think there's this, just like the cops you were saying, by reciting the Miranda rights, habituate the ideas in it into their mind, into the culture of their life. When you're having to, and maybe this is more true of defense attorneys, when you're having to essentially argue vociferously for something that you think is wrong, that you maybe even feel is absolutely, definitely wrong. Like if you're having to defend a person that you believe is guilty, it seems like it can create this sort of ends justify the means type of culture. Can you speak to that? Can you speak to sort of the different forms of corruption, not just the system corruption like payola, but even like the personal ethical corruption that you're dealing with when you're in these messy cases and there's different opportunities to try to say, well, do the ends justify the means here?
Well, I talk about that specifically in felony review, personal corruption, what that consists of. It's a very interesting topic. It's a very interesting question. Thanks for asking that question and asking it the way you just did. It opens up a couple of different issues. Number one, the mindset of defense attorneys. I've already said defense attorneys are absolutely essential to the proper operation of the adversary system on which our criminal justice system relies. And when they fall down in their job, that's really when innocent people get convicted. Because the prosecutor's doing their job and they expect to be met with resistance. And when there's no resistance, then things can go awry and innocent people can be sent to the penitentiary. Most examples of wrongfully convicted people were badly represented at the trial court level, and the lawyers that got them out were their appellate lawyers that came to their rescue later on. I've never been a defense attorney, so I can't really speak to this. I should have thought that would be enough motivation for a defense attorney to do the defense attorney's job. But it turns out in many cases it's not enough motivation for the reasons you said. And they ultimately end up becoming hostile to the legal system as a whole, thinking all police are liars, all prosecutors are abusing their power. They make it an us-them conflict when it doesn't really need to be an us-them conflict because doing the job properly is part of the job, is part of the system, and we rely on that. So I don't understand, because I've never been there myself, what the temptation is to have that mindset, but that is part of what happens to some defense attorneys. They get very jaded about the system as a whole, as a way of justifying what you say, arguing, trying to get people who they know are guilty free. How do they justify that to themselves? Not the right way, but this wrong way. There's another kind of corruption, however, on the prosecution side that I faced, and it's not the kind of corruption that I was talking about before, which was payoffs. In Cook County, my prosecutor's office was clean. In fact, Cook County was less corrupt than I expected it to be on the basis of my father's telling me, he was a small businessman from Chicago, telling me how corrupt it was, because I fully expected the office I was going to go work for was going to be corrupt because everything was. It turns out it wasn't. The prosecutors I prosecuted, I'm not saying there was, of the 550 lawyers in the Cook County State's Attorney's Office, there weren't some bad actors who were gotten rid of. None of us really heard about them, but they got rid. But believe me, I never ran across one of them myself. Although I talk about somebody who left the prosecutor's office to become a corrupt lawyer, I talk about that, not in the prosecutor's office itself. So it was clean. And the other thing is, in Cook County, no one needed to approach any of us to fix a case when they could approach the judge to fix a case, or they could approach the cop to fix the case. They didn't need us for that. So I was never approached to fix a case, and I don't think I ever would have been, even in a more corrupt system. As long as you make it known that you're not corrupted, you're not corruptible, people won't even try to corrupt you. But then there's this other form of corruption I discovered, which is more personal. And I put this in the book, even though it pained me a little bit to do it, and that is there's a corruption that comes from having power. And being an assistant state's attorney in Cook County, and I tell stories to illustrate this, being a state's attorney in Cook County is a very powerful position, and it is perceived to be a very powerful position. And as a result, you get what you might call extremely fair treatment from government agencies of various kinds and government officers of various kinds, including traffic policemen. You get extremely fair treatment if not generous treatment, just because you have that office, you hold that office. And I can tell you that feels good. It feels good. I tried really, really hard to adhere to the speed limits because I didn't want to be in a position of having to influence the cop to let me go if I was speeding. But every once in a while, I slipped up and I was speeding, and you know what? The cops always let me go, and it felt good to have that kind of immunity. We were given we could buy baseball caps that had a patch on it that said Cook County State's Attorney. They gave it to us because state's attorneys started wearing Chicago Police Department caps, and the supervisors were afraid that at a cop bar sometime some cop would take offense at a state's attorney wearing a cop hat and get in a big fight. So they said, okay, we got to give them their own hats to wear, so they don't have to. This doesn't happen. So we all got our hats, and let me tell you, whenever I wore that hat into any bureaucracy, whether I was applying for a building permit or something else, when I was wearing that hat, they treated me really, really well. And I wore that hat for even after I left the prosecutor's office because it was my father nicknamed it my magic hat because I magically got fair treatment that other people might not have gotten but should have gotten by government officials. And so that was a form of inner corruption, I think, where you like the power and you don't want to give it up, which explains why these office holders will never go back to the private sector. Because once they've held the privileges of power, they like it. And they don't want to give it up any more than a drug addict wants to give that up. And I'm very, very glad I gave it up after 4 years. It took me a while to adjust to being an ordinary citizen again. But it was a very healthy thing to do, and I give that warning that this is what was meant by power tends to corrupt, and ultimate and absolute power corrupts absolutely. I think this is the kind of corruption that's being discussed that refers to, and which I personally experienced.
You mentioned that you're working on a book about libertarianism, and I certainly consider myself broadly to be a libertarian. But contending with power, even as a concept, is among the weak points of the philosophy of libertarianism, which if I will summarize libertarianism in the most basic way, it's do whatever you want so long as it's peaceful, so long as you're not hurting anybody physically or stealing their stuff. You buy more or less live and let live. How do you think about this gap? We touched on a little bit in our last conversation that this sort of grappling with power has always been sort of the purview of the left-wing intellectual, the Foucault types. And while a lot of those folks are reprehensible, it's worth grappling with power. So how have you done that?
Well, it's funny you should mention that because that is a central theme of the new book. The new book, which is called Freedom and Flourishing, Libertarianism for the Real World, addresses a number of issues that what you might call ideal world theory libertarianism does not address. One of them is the problem of private power, which it basically libertarians tend to wish away. It's the make your own internet. If the internet keeps you off the internet, build your own bank. That philosophy. And I take the problem of private power seriously. And I do agree with you that this is a problem that has been basically viewed from the left and not from libertarians or from the right. Although I think some people who are considered conservative, they also think about this as well. Libertarians have specifically not been thinking about this. And I put that central in this book. Now, I have to build to it because I have to say exactly what the problem is with public power, when it's a problem, and what the limits are. Because what the left wants to use the problem of private power to do is to collapse the distinction between public and private power, saying it's all about power, and when we're going to do whatever we want to stop power. That's not true. There is a difference between public power and private power, but private power is a problem, and it needs to be addressed, and I will address that. Most importantly, let me just say, without I'm not giving away any spoilers here. Most importantly, to defend civil rights laws that provide equal access to infrastructure that's necessary to flourish in a civil society that one's a member of, and that would include the ability to travel throughout the country, to utilize public services, but also to utilize public-facing privately owned services like gas stations, hotels, restaurants, the kind of thing that the Civil Rights Act of 1964 was successfully opened up to African Americans. But also, and this had a big influence on me, the book on the 14th Amendment that I wrote had a big influence on me because in that book I spent a lot of time, my co-author and I spent a lot of time talking about the Republicans in Congress that passed the Civil Rights Act of 1875. And that Civil Rights Act also criminalized or made against federal law the denial of equal access to places of public accommodation, to inns, theaters, railroads, places of public amusement. That law was held unconstitutional in 1883 by the Supreme Court because it reached private power and not public power. And in the 14th Amendment book, I explain why that was a mistake, why the Constitution did not undermine that law. That was a tragic mistake because that civil rights law, which mirrored the one we got 90 years later, would have averted 90 years of Jim Crow if it had been enforced. And so that's what I learned. I learned about this as a libertarian by studying the 14th Amendment, by studying the philosophy of the Republican Party and the Republicans in Congress during that period of time. So that book had a very serious effect on my view as what a libertarian today should be for and why they should be for it. But it required me to go revisit first principles. It wasn't enough to say, well, these Republicans did it and I like it. And I had to figure out, were they right to do it? And the conclusion of the book I'm currently writing is, yes, they were right. And what they were doing should inform what libertarians believe should be done today.
I'm going to switch books here. The original meaning of the 14th Amendment, its letter and spirit. And it's not just about birthright citizenship, though we should talk about that since this is one of the issues about, I think, to be perhaps decided by the court, at least in response to the Trump administration. But there are a bunch of concepts in here, and a bunch of in here, as in your book, and the 14th Amendment. What should an American understand about what the 14th Amendment put forward, and like what's been the most sort of important aspects of it? Because it wasn't just about slavery; it had more far-reaching implications than just the post-slavery United States.
Well, for sure. And I should just mention, my co-author and I, Evan Bernick, do not talk about birthright citizenship in the book at all. There would be two reasons for that. Number one, it wasn't on the table. It was an obscure issue that was not on the table. Number two, had we talked about it, we probably would not have agreed. We had to reach agreement in order to publish the book. We never reached that stage because we weren't going to talk about it. The 14th Amendment has 5 sections. We talk about Section 1. We talk about citizenship, but we don't talk about the birthright citizenship aspect that's in Section 1. So I should just say you're not going to find an answer to that question in that book for a good reason. Now, as for what I think you will find in the book is that the 14th Amendment, which was enacted after the 13th Amendment abolished slavery. Everybody pretty much knows that. It was 2 sections. The first section abolished slavery or involuntary servitude, not in punishment of a crime, which could actually bring us back to our criminal justice topic if we wanted to go that way. I don't think we should, but it would. And then there was a Section 2 of the 13th Amendment that gave Congress the power to enforce Section 1. So after the Civil War, I think most of the opponents of slavery thought, boy, that was going to do it, man. We fought a Civil War, we won the Civil War, and we got a 13th Amendment. If slavery's gone, let's just go. And we're going to go. They hadn't anticipated Southern resistance. This is like we're seeing Iranian resistance right now. You'd think you pummel them, but they still resist. Well, Southerners did not want to – they may have surrendered their sword, but they did not surrender. And they continued to do and tried to reconstruct as best they could the subordinated status of free blacks to the point where they were reduced to slavery. And they did that in a variety of ways in terms of regulations, including depriving them of the right to keep and bear arms and affecting their right to enter into contracts. They used every tool at their disposal to recreate some kind of slavery-type relationship after the abolition of slavery. Well, the Republicans in Congress did not take that lying down, and they passed civil rights laws, including the Civil Rights Act of 1866. But that law was vetoed by Andrew Johnson, who took Abraham Lincoln's place after Lincoln was assassinated. And he vetoed it on the ground that Congress, in trying to reach all of these other abuses, was going beyond its power to abolish slavery. Slavery's gone, he said. This other stuff is not slavery. So therefore, you can't reach it. Well, many in Congress disagreed. His veto was overridden by a supermajority, but not everybody disagreed. A key congressman from Ohio, John Bingham, thought President Johnson might have had a point. And so Bingham pushed for a constitutional amendment that would ensure that Congress had the power to pass civil rights laws to protect the liberties of free blacks. And that's what the 14th Amendment was. It was a do-over of the 13th Amendment, broader, to try to address the resistance that the Republicans were seeing happening in the South. But by doing it broader, they didn't limit its protections to African Americans, to free blacks. The protections provided by the 14th Amendment apply to all citizens and to all persons. Some of them apply to citizens, some of them apply to persons, but it isn't limited to black or white or men or women for that matter. It was to protect everybody. And so it was broader, and it does have implications. And so it resulted in a fundamental structural change to our system of government. We're about to celebrate the 250th anniversary of the founding of the country, and we did have a founding of the country. The Declaration of Independence was our founding document. Then we had two cracks at government, the Articles of Confederation, which by all accounts, even by the people who opposed the Constitution, they thought the Articles were no good. We needed something else. But then we had the Constitution. And you could consider the 13th, 14th, and 15th Amendment to be a third crack of government. And what was the difference? Under the first form of government, actually under even the first and second, if you count the Constitution as the second form of government, states were considered the harbingers, the protectors of liberty. The federal government was considered to be the threat to liberty. So all the constitutional limitations had to be aimed at the federal government, not at the states. By the time we get to 1868, by the time we get to after the Civil War, guess what? The states turn out to be the engine of injustice. The states turn out to be the group that sanctions the ownership of some people by other people. And then when that was formally abolished, they continued to try to subordinate some people at the hands of other people. The states were doing that, and the states were doing that by action, and they were doing that by inaction, by letting private parties do all their dirty work as well. And the 14th Amendment was meant to counteract that. So what it changed was it put a federal check, because the feds are the ones that won that war. It put a federal check on state power that simply didn't exist at the founding. And that is why, for example, you can make a First Amendment claim or a Second Amendment claim against the states. It's not because of the First or Second Amendment, because they only apply to the federal government. It's because of the 14th Amendment that you can bring those claims against states. That's a big change, and it was for a change for the better.
So explain exactly how that works, because it's true. We tend, myself included, tend to lionize essentially the original Bill of Rights, which ends with the 10th Amendment, right? The everything not enumerated here goes back to the states, which reinforces your point that essentially you could have state-sponsored religion, and as I understand, a lot of the constitutions of the early states had explicit state religions, all Christian. Charlie Kirk has made this point that while, when people talk about are we a Christian nation or not, those who want to say we're not will point to the federal government and the Constitution and the First Amendment and the Establishment Clause. But at that time and in the immediate aftermath, it's like, well, there were states that had actual state-sponsored religion. So what happens in the 14th Amendment that gives teeth not just to the 13th, but to the state enforcement of the rest?
Well, I'll tell you how it was supposed to work, and then I'll tell you how it actually works now. There was a provision of the Constitution after the Citizenship Clause, which is what the Birthright Citizenship debate was about. That was the first sentence. There's four moving parts of Section 1. The Citizenship Clause, the Privileges or Immunities Clause, the Due Process of Law Clause, and the Equal Protection of Laws Clause. There's four provisions. Each one of them are important. The Citizenship Clause, we're not going to talk about right now. The next clause sounds really important. It says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Let me say that again. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. At a very minimum, those privileges or immunities were the ones in the Civil Rights Act of 1866 that Andrew Johnson had vetoed because it was beyond Congress's 13th Amendment power to enact. When they passed the 14th Amendment, they wanted to ensure they had the power to enact it. And even after they enacted the 14th Amendment, they repassed the Civil Rights Act of 1866 just to be sure it was coming in under the 14th Amendment as opposed to the 13th this time.
Well, now, I want to make sure I understand this concept. Privileges and immunities. What does that mean? So I've got all these words about, like, you know, the Congress shall pass no law that does this or that in the Bill of Rights. But what constitutes a privilege and an immunity? Where do I look to know what those are?
Well, that's a very good question. We spent a lot of time in our book talking about just that question. I'd like to postpone that question as I kind of tell you why it is you've never heard about this.
Yeah.
Why do you think that sentence I just read to you twice now? If you came down as a alien in one of those, one of those ships that we're now being given videotape of, and you heard that language, you think, well, that's pretty darn important. That's really important. No state shall make or enforce any law which shall abridge the privileges or immunities of the United States. Well, it turns out 5 years after the 14th Amendment was enacted, the Supreme Court, in a case or a series of cases that were aggregated together, and they were called the Slaughterhouse cases, they basically rendered that clause a nullity. They gave it a meaning that was so narrow that it basically didn't apply to anything of any importance, and it went away, and it has only been invoked one time from 1873 until 2026. It's been invoked one time by the Supreme Court. It has disappeared. It has become an unclause. It doesn't exist anymore. That's why you've never heard of it. That's why you don't know what it means. What happened after that? What happened after that was eventually, in order to provide this check on state government, the Supreme Court expanded the original meaning of the Due Process of Law Clause, which says no state shall deprive any person of life, liberty, or property without due process of law, nor deny to them the equal protection of the laws. They expanded the Due Process Clause and the Equal Protection Clause to make up the absence of the missing Privileges or Immunities Clause, giving both of those clauses a meaning beyond their original meaning. But to give the original meaning of the Section 1 of the Constitution as a whole, bringing it closer to its original meaning, because it's got this missing clause. It's sort of like if you lose a tooth, the other tooths start to move close to fill the gap that missing tooth has created, and so that's why you don't know what it means. And there have been efforts, many efforts, to try to put that back in play, and it's been argued for many times, and I've been part of the people that have been arguing for it, why that clause should be restored. And the conservatives on the Supreme Court, along with the liberals on the Supreme Court, adamantly refused to do it. And they adamantly refused to do it because of the question you asked me. What are these privileges or immunities? How are we going to figure that out? Mm-hmm. And it's too hard. Therefore, let's continue to forget about it. And that can't be the right way of going about it.
As a non-lawyer, but I think regardless, just as an American, trying to grapple with the language of the language we hear about our rights, what is said in the Constitution, and then what has been done to it, is it gets pushed around a lot. So, is it Filburn? Wickford v. Filburn, that basically says you, under the guise of regulating interstate commerce, you can't grow wheat for your own consumption on your own land? Am I remembering that correctly?
You are remembering the story of Wickard versus Filburn that's told correctly. It turns out it's not the actual Wickard versus Filburn, but it is the way Wickard versus Filburn is taught to every law student, and most judges who sit on the bench accept that rendering of what Wickard versus Filburn said.
So so
you're right.
Yeah. So, but okay. So, but does that mean we're all getting it wrong? What's the?
Yeah.
Yes. Yeah. So,
and it was during the medical marijuana case that I took to the Supreme Court, which you mentioned earlier. I went from trying murder cases to juries to arguing a constitutional case in the Supreme Court. Something I never thought I would ever do. Something I never really even aspired to do. But ultimately, it's something I did, and I'm glad I did it. I'm glad I did it one time. I don't ever aspire to do it again. It was a lot of pressure, but it was learning. It was during that litigation that I I actually read Wickard versus Filburn more carefully and saw what it does say and what it doesn't say. And I think it's a side issue to go into that as to, I don't know that it's worth explaining why the standard interpretation is wrong. But the standard interpretation is what most people accept, so it might as well be the right interpretation, I suppose.
Well, the reason I bring it up in the context of a conversation for general consumption is that we have a government that is constituted by a document which goes out of its way to limit its power, and yet we have what appears to be a fairly limitless amount of use of power. I know it's not limitless literally. Presidents, including President Trump, for all his muscularity, they get checked by all kinds of different things, including the courts, including public opinion, and lots of stuff. Lots of stuff checks power. But, the Constitution in practice as a document that's actually alive 250 years post-founding, I think for a lot of Americans, they just wonder, like, they don't, is this still relevant? Does the Constitution matter? Like, if the government can do all these things and get away with it that just seem to violate the most plain reading of the text, what's going on here? And I guess that's sort of a broad question, but it's like, for somebody that feels that way, what's your answer?
Well, first of all, I don't think most Americans are asking the kind of questions you've been asking because you're involved, you're engaged. I think if you just ask most people, their gut tells them good things are constitutional, bad things are unconstitutional, and so tell me how the case comes out, and I'll tell you whether I agree with it or not. I think that would be what the people that haven't been to law school think. I know you haven't been to law school, but you exist in this intellectual space, and so you can put a question like that. That does bother a lot of people who care about the Constitution. It bothered the people in the Tea Party movement, which I was involved with back in the day. I talk about that in my memoir, A Life for Liberty, that we did the last show on. And so, yeah, they're bothered by that. So there's a couple things to be said about it. First of all, you've already given part of the answer, and that is that a lot of the checks and balances that were built into the system, the structural constraints of the Constitution, they're still running. They're still up and running, and they are very responsible for why government has remained as controlled in this country as it is. Now, I'm not saying it's very controlled because I think it isn't, but it's more controlled than it would have been, way more controlled. There's a reason why we're still a free country, even though these limitations on government power have been overridden by Congress and the president, and then the courts have said, yeah, that's fine. It's fine with us, fine by us. Go ahead, continue to do that. That's what Wickard versus Filburn is. Yeah. The court didn't pass the Agricultural Adjustment Act. The court just upheld the constitutionality of the Agricultural Adjustment Act. And so, yeah, those bounds have been superseded, but a lot of the structural constraints are still there, although there are people who would like to do away with those structural constraints, and that's a problem. So that's part of it. The other part of it is we did get an enumeration of a few of our rights. We didn't get them all, but we got a few of them. We got the right to keep and bear arms. We got the right of free speech, the right of freedom of assembly, the right of free exercise of religion. We got those rights, and the courts have been, at least in the last 100 years, increasingly protective of those rights. And that's also a reason why we're still a free country, because the few rights we got turned out to be, important ones. And also, once you recognize the right of free speech, then you find out everything is speech because everybody wants to get their thing under the protection. So the definition of speech starts getting broader and broader in order to bring everything in because that's the only right that gets protected. So those are the two ways in which the government stays somewhat constrained, but we can do better. And you know what better is? Better is following the original meaning of the whole Constitution, not just part. The original meaning of the Privileges or Immunities Clause. Hey, how about the original meaning of the Ninth Amendment that says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people? Another provision that if you came down from outer space, you'd say, well, that's a big deal. And then you'd be only to be told, well, the courts never, ever use that one. That one's off the table too. So if we had the whole Constitution back, we would do better than what we're doing now, and that's what I'm committed to as an originalist, constitutional scholar, do constitutional law. I don't do criminal law. I don't do contract law anymore either. As originalist constitutional scholar, my aim is to restore what I call the lost Constitution. That was the name of my first book on the Constitution, Restoring the Lost Constitution. The lost Constitution are all these missing clauses that we'd be doing a better job if we brought them all back.
One of the, it's due process is part of the 14th. One of the things...
And the 5th. It's the 5th and the 14th. They both have due process of law clauses.
Yeah, so I think this notion of equality under the law is something that has come under a lot of pressure because of identity politics and this, the aftermath of the Civil Rights Act, right? So you have these provisions, this notion of protected classes that has been like this sort of sticky ball rolling down a hill, picking things up as it goes. How do you think about that? We're in this, we're not in a fully post-DEI world, but DEI is certainly on its back heels relative to just a couple of years ago. And that whole philosophy basically says, no, we're not all equal under the law, or we shouldn't be. The law should treat us differently based on who we are, among many assertions in that philosophy. But that's sort of a central one, and the whole critical theory thing came out of law school, came out of UPenn and these law professors. You're the folks on the other side of the aisle, but in your domain. So help people understand sort of the constitutional pushback on woke and DEI and treating people differently under the law.
It's a big topic. Before I get granular, let me go big picture. Because I already mentioned that due process of law got expanded because the Privileges or Immunities Clause was eliminated, and so did the Equal Protection of the Laws Clause. The Privileges or Immunities Clause also protected against inequality. That is, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, any citizen. So if you get the right to keep and bear arms and you don't get the right to keep and bear arms, that's a violation of the privileges or immunity of citizens of the United States. You don't need an Equal Protection Clause. The Privileges or Immunities Clause was supposed to do that work. But the other two clauses get expanded, but it's so that they don't take over the whole field. Once they get expanded, limits were put on them. So the limit that was put on the Due Process Clause was that only fundamental rights get protected by the Due Process Clause. What is a fundamental right?
Yeah.
Well, the enumerated ones, maybe, by now they've almost all been incorporated. They were all considered fundamental. They weren't at first. And then maybe some unenumerated rights, like the right of privacy, let's say. Well, that was a controversial one. But how about the right to raise your own children? That's not enumerated. Do you have that right? I think you do. But that's a problem. You have to be fundamental. If it's not fundamental, if it's a mere liberty interest, you get no protection. Well, that's not the way it was set up. That's what happened with the Due Process Clause. With the Equal Protection Clause, you have the same problem. With equality before the law, does that apply to everybody? Well, it turns out we're told it only applies if there's a suspect classification that's being used. Only some people, the people in the suspect class, get protected. If you're not in the suspect class, you don't get protected by the equal protection of the laws. At least you don't get the same level of protection. And that's another restriction that's imposed on the Equal Protection Clause because otherwise it's going to go crazy and go wild. So these are all judge-made restrictions on judge-made expansions. How about that? We have judge-made restrictions on judge-made expansions because some five justice of a 9-justice court decided that the privileges or immunities in 1873 that the Privilege Immunities Clause was got to go because it was too broad, it was too big. The Republicans would put off more than they can chew, and so we got to move on from that. Now, getting back to DEI, which is slightly a separate topic, you'll notice that equality before the law or equality has been replaced by the word equity, and that replacement, that substitution is conscious because equity is the definition of equity is meant to be equality of results, not whether you have equality of treatment in front of the law, right, which is what equality most lends itself to. And so by this switch in terminology, you get a switch in emphasis. And it's all done because of a political ideology that's not supported by the original meaning of the Equal Protection of the Laws Clause or by the Privilege and Immunities Clause. Let me just tell you what the core thing that the Equal Protection of the Laws Clause was there to attack. There was a big problem. It gets back to what we were talking about earlier about private power versus public power. And that is, it was a failure of Southern governments to protect free blacks from private power that violated the equal protection of the laws. The Equal Protection of the Laws Clause provides an affirmative duty on the part of the state to provide the protection of the laws equally. which was not happening. That was what was not happening. And then when it didn't happen, Congress passed its own law to step in and said, okay, if you can't get your rights enforced in state court, you can come to federal court. We'll enforce your rights against private power intruding on your ability, your privileges or immunities of citizens. That's what it was for. But then that got gutted by a different Supreme Court case that said that the 14th Amendment only protected against state action. And it couldn't protect against private power. So that's part of the problem with the Equal Protection Clause. But remember, it was all about the failure to protect. It was not about going out into society and using a clause to get equal results of everything that may happen in society. That's not what it was about. It was making sure that non-discrimination laws that did already exist in the common law were going to get protected effectively. If not in state court, then it would be protected in federal court.
How do you think about discrimination more broadly? And what I mean by that literally is we have to discriminate all the time for everything because every decision we make involves a discrimination. Where I'm going to go out to dinner involves making discriminating judgments. Deciding whether I'll hire or not it involves 1,000 variables that are discriminating on the basis of judgment calls that are all pretty subtle often. Like, do I think you're going to be good at your job? Do you look messy? Like, did you get on your Zoom call for an interview and your room is a mess? I'm less likely to hire you if you get on into a Zoom interview and your room is a mess, because that might mean you're a mess and that might mean you're going to make our office worse. I'm discriminating against your behavior, and it might even be things that you struggle to control. Maybe you can't help it. You really want to be a tidier person, but you just can't do it. Like there's almost no end. It's hard to even take if you just take away the way we generally use the term discrimination, which is just to say it's about race or about gender or whatever, and use its general definition. It's like it's not even clear that you can have choice without discrimination. So maybe I'm just monologuing here a little bit, but how do you contend in your great legal mind with like where discrimination goes from being like a fundamental notion of choice and freedom to something that may have crossed a line?
Well, this is what I'm wrestling with in the new book. And I do have some answers in the book as it currently drafted. I think I'm going to have to say more about it than I already have in the book that you haven't seen yet because I'm still writing it. But I think it's a super fundamental question. And I think there's like two different things that there's a distinction two different distinctions should be made in dealing with this issue than normally is. The first is, what is the thing that you are being discriminated about? And that's what the Civil Rights Act of 1875 was about. It was discrimination with respect to places of public accommodation, common carriers like railroads and trains and canals, and places of public amusement, places where the individual citizen went out into the public and had to interact with other citizens on public property, in the case of sidewalks and roads and alleyways, but also in these public-facing provisions of these goods and services. And when those, and what I describe those in the book, I describe those in the book as infrastructure. And so it's not whether somebody has the right to force themselves onto your podcast, but does AMS have the right to cancel you and cancel anybody AMS, which is the network, the people that provide the internet, can they just turn away people because they don't like the viewpoint of what they said? Anymore, can your cell phone company cut off your cell phone because they don't like what you're saying on the cell phone?
If Google and Apple decide that your app carries too many white supremacists or whatever, like they did with Parler, can it just be wiped off the face of the planet?
That's the question. I mean, I'm not saying what the answer is at this point, but that's the question. And I do think infrastructure is different than other kinds of activities. That's the first thing I would say. The second thing I would say, the other distinction that has to be kept in mind, is the personal versus the corporate. And that's a distinction I made in contract law years ago when I talked about remedies and why there was a common law rule against enforcing personal service contracts specifically, so that if you breached a personal service contract, you could not actually be made to perform. You could be made to pay damages for not performing, but you couldn't be at a point of a gun made to perform. Whereas companies can sometimes be made to perform. Now, what's the difference between a person and a company? Well, a person would have the kind of objection to discrimination that you were articulating. All the hypotheticals that you were describing were personal in nature. Companies are different. They are artificial persons in a way. Now, they are an aggregation of natural persons, but they're being administered by a managerial class that's not the same thing as the owners of the company, who are the shareholders. And somehow they are providing these services, and they are being authorized by the state and being benefited by the state in terms of getting limited liability and other sorts of things that attach to corporate status. Should corporations, and when they deliver services, be treated, or hire people, should they be treated the same way as individuals when they deliver services or hire people? The thing about Jack Phillips and the Masterpiece Cake Shop case is that was Jack Phillips. That wasn't McDonald's. Ray McDonald's has nothing to do with McDonald's anymore. Hasn't had anything to do with McDonald's since the thing was taken away from them. This is, or not Raymond, that was Ray Kroc. Whoever the McDonald's guys was, he got the name from them. There is no McDonald's. And so, but there is a Jack Phillips. Making Jack Phillips express himself by using his artistic talents, that's a problem of liberty. Making Stop and Shop, making Publix, making them say, as long as you have money and you obey the rules and no shirt, no shoes, no service, but you do all of those things, you come in to buy food, but we're not going to let you in here because you're a citizen, but you're not the right kind of citizen. You can't buy food here. That's different than making Jack Phillips bake a cake. And so I think if as libertarians, we start working on those two distinctions, one is public-facing infrastructure versus our own homes, and in the privacy of our own homes, and we'd make that distinction, and we also make the distinction between what's really personal and what's corporate and impersonal, then I think we can make some traction on when discrimination is not only allowable, but desirable, as you say, to when it's prohibited on the basis of irrational characteristics that have nothing to do with the actual provision of goods and services.
We're in the weeds, which is great because that's what long-form podcasts are for. And I think these are such important weeds because we are in the aftermath of a period in which identity was pushed to the center of public discourse at all levels. Between the George Floyd riots and Black Lives Matter. I mean, basically, there's been a series of things in our culture that have pushed identity to the center on top of, and then supercharged by ideology, the Me Too movement, all of this stuff, trans, all these things bring identity into the foreground and make differences that you can tell from across the room, or maybe sometimes can't, seem to be the most important thing in the world. And the question of what's the law say? What kind of society are we living in? It ends up being where the rubber meets the road. I'm allowed to do that. I'm not allowed to do that. It's a pretty important thing to understand as an American. The court's gotten more conservative. We have 6 conservative justices, more originalist. When there's been pullback on the Voting Rights Act, right? So how do you understand the trajectory of the Supreme Court when it comes to all of these identity-related issues? Are we moving towards and should we, a sort of post-civil rights era?
Well, the answer is we're not moving to the pro-civil rights era. The happy answer to that question, that's not happening, despite what you may have read. But before we go to the Supreme Court, I want to stand back a little bit. You said we got into the weeds. We certainly got into the weeds. But I want to make a plea for philosophy, political theory, and academia. I want to make a plea, and the liberal arts, including in academia, and make a plea for my job. My job as a law professor. Because nowadays, higher education is under assault, I think, for good reason, frankly, and it deserves what it's getting, and it should get it good and hard. So I'm not opposed to that because it's been teaching a lot of bad stuff, and it needs to teach better stuff. We've been gutting the liberal arts. But in a division of labor, it explains why I went from being a practicing attorney to being a law professor. I went there for specifically this reason. I wanted to give more systematic attention to what the requirements of justice really are than you could do as a prosecutor, a line prosecutor in the Circuit Court of Cook County, or I could do as a partner in a law firm or any other capacity practicing law. So that's the division of labor. That's what I get paid a salary to do. And that is to do this sort of analysis and produce the more theoretical books, not the 14th Amendment book, but my first book, The Structure of Liberty, Justice and the Rule of Law, which is about the nature of why we have natural rights of property and freedom of contract and other natural rights as well. And the new book I'm writing, Freedom and Flourishing, a libertarianism for the real world, in which I'm trying to come to grips with exactly the questions that you're answering. My answers at this point are tentative. I haven't published this. I'm writing it. I'm wrestling with it myself. But that's my job, and it's a job somebody really needs to be doing. And what better person to do it than a law professor, or a philosophy professor, or a political science professor? But that's our job. And so, give me a break. I do think that what we do, if we do that, is important because folks like you who are extremely thoughtful and can raise you're really good at raising all the hard questions, but you got to come up with somebody's got to come up with answers to the hard questions. That's why you're asking me. And why are you asking me? Because in a division of labor, it should be my job to think these through, and that's what I'm trying to do. But to do that requires me, I can't just do it out of my head. I have to work it out, and I work it out between my word processor and me. That's how I work it out. And I work it out over time, and I work it out over 40 years of being a professor developing the theory of liberty. And this book that I'm writing is the culmination of all of those things. Pretty much everything I've ever written has relevance to this new book. I invoke it, but I go beyond it. And I just want to make a plea for my line of work. And it's a great line of work. If you can still get this job, and it's a hard job to get, you should go for that. Just like I say, people who are interested in the criminal justice system, they should go for that because that's a job that's better than TV. And being a law professor is not on TV, so you don't know what that job is. But the better than TV job is the one I wrote Felony Review to describe.
I think it's an important plea in this moment in the sense that I think, there's this quote by an economist I mostly dislike, John Maynard Keynes, that essentially practical men are under the sway of some academic scribbler in the past. And it's, I used to be able to recite this quote exactly. It's at the end of my first Hayek-Keynes rap battle. But basically, it's like practical men who believe themselves to be quite, immune of any intellectual influence are usually under the sway of some dead economist, something like that. One of the things that's happened personally, as someone who's obviously kind of an intellectual type of guy, but not formally in your line of work, is we have had our trust as a body politic, as a people, violated by your class, the class you're advocating for, so thoroughly that it's pretty hard. I think your plea is a good one. It's a good thing to talk about for a little bit because it is like maybe the world would be better off without any law professors. No offense, Randy. How much destruction has been wrought by law professors, especially in the past 40 years? Why? We have the First Amendment. We have this broader notion in the West, certainly, of the freedom of conscience, the freedom to try to grapple with your thinking through speech, through action, through association, because you don't know the truth and so you're in pursuit of it. We have the notion of the scientific method, which essentially, if you understand what science is, there's no the science, basically says, look, there is no settled answer to any question except in heaven, if you believe in God and heaven. And therefore, we're always up to reimagine, reinterpret reality. Oh, heck, we thought the smallest thing was an atom. Turns out you smash them and there's smaller stuff still. So I'm monologuing here, but it's towards an end, which is that why has this field, why has this discipline, which you've already admitted is rife with problems, why has it become such a problem? Because it really has become so lopsidedly a problem that saving the academic pursuit so that like anybody to the right of Bernie Sanders doesn't think it's a bunch of like quack commie nonsense is harder than ever. Even for me, I'm like, nah, that's a bunch of quack commie nonsense. Shut up. Like,
well, nobody knows quack commie nonsense like I do, because that's the world I live in. I live in the world of quack commie nonsense. They're my colleagues, and they've always been my colleagues, or they're my adversaries, and they've always been my adversaries, and those are the people with whom I do intellectual combat as a law professor. And I want to say it's usually me, not you, and not the other people who are saying how don't blame the judges for adopting these theories, because whatever theory a judge adopts was probably the product of some smart aleck law professor first, and they're just taking it on board. And so blame the law professors, don't blame the judge. So I hear you, and it may very well be, and I think there's a good case to be made, that our most elite institutions are beyond repair. Even Georgetown Law, where I'm very happy to be a law professor, we have 3 right-of-center professors out of 130, and that's not going to change anytime soon. Now, I do have a bigger footprint at Georgetown because I run the Center for the Constitution there, which I founded, and my colleague Stephanie Barclay and I both run this, and we have a big impact on many, many people because I'm doing it from Georgetown. And the way to go at these top elite schools that are not coming back is to have these centers that operate sort of autonomously and can provide some support for right-of-center students, libertarians or conservatives, which need our support in this overwhelmingly left-wing environment that they're being brought into. That might be the best we can hope for. Down the market, we can hope for better than that, because we have red states that have state schools that have developing civics institutions and liberal arts institutions within the schools. You see this at Florida. You see it at Florida State. You see it at Ohio State. You see it at Texas, Tennessee. These are all states that have generated different kinds of programs. I've spoken at many of these. Arizona State's another one. And you can send your kid to the University of Florida, the flagship state university in the state of Florida. You can send your kid to the University of Florida, have them enroll in the Hamilton Center, and they can get a strong liberal arts education that's designed to be that way. They just can ignore all the bullshit that's happening in all these other departments. Now, these other departments hate that. Yeah. But this is the way you work around it. And then there's the third workaround. Create new institutions like the University of Austin in Texas, or New College, which was not a new institution but was taken over by the Republican governor to make that a more Hillsdale type of environment. So we have to attack this problem at different ways, at different levels, depending on what we're talking about. But we can't. But my earlier point, and I think you're not disagreeing with me about this, that in a division of labor, somebody should be doing the kind of connections, making the kind of theoretical connections between things that an ordinary American who's going about their daily business, they're not going to do that. And neither are even intellectuals who are specializing in this, that, or the other thing. Now, to be an intellectual like this, or theoretician like this, you don't have to work for a school. I mean, you could do it. Lysander Spooner, who developed a theory of originalism that attracted me, he didn't work for a school. He was a very impoverished guy his whole life, just writing book after book.
Didn't he work for the post? Did he work for the post office? Am I misremembering that?
No. He created his own post office to compete with the U.S. Post Office, and then they put him out of business by prosecuting his letter carriers for violating the express mail statute. And then they bankrupted him before he had a chance to contest the constitutionality of what they were doing. So it's an interesting story that you remember. Anyway, the point here is that there's a place for people to do political theory, and somebody needs to do it, if nothing else, than to respond to all the commie bullshit theory that has been developing since the rise of progressivism at the end of the 19th century into the 20th century, that eventually got rid of the concept of natural rights, got rid of the concept of natural law, got rid of the concepts of freedom of contract, made private property enigmatic. We've been facing an onslaught of a takeover of academia by this form of intellectual positions, and some of us, we need to fight back, but we have to fight back in the terms in which this debate is taking place, at the terms of first principles. What are our first principles? This is what we got. What are our first principles as a libertarian? My argument of my new book is libertarians have not thought their first principles through. And the questions that you've asked me in this program are raising questions about those first principles. It's my job as a libertarian intellectual and a law professor and an originalist to try to do the best I can to advance the discussion of first principles, and then we can go from there.
I do want to touch on the notion of birthright citizenship and your take on the current legal proceedings, because you certainly had to grapple with it, even if you didn't include it in the book, for the reasons we already talked about. And I want to do that on the way towards a broader question of the Constitution that is in each of us, that the Constitution that lives in our culture. But let's start here. The court, as I understand it, is weighing right now, and may even any minute, weigh in on President Trump's executive order seeking to limit birthright citizenship. How do you understand, having written this book, even if it's not really grappled with in here, how do you think about whether the 14th Amendment does grant anyone born here citizenship, and whether it should or shouldn't?
Well, the text of the Constitution does not do that. But I will get back to why I say that in a minute. I will tell you the other reason why we didn't address it in our book, besides what I said, it was a distraction, and we weren't sure we could even agree with it ourselves. I didn't know what I thought about it back then, and because I heard arguments on both sides, and neither argument resonated with me. I heard arguments in favor of it. I heard arguments against it. And it was like, I don't know. And the only way I'm going to find out is to go back and immerse myself in the sources and try to figure out, well, what did they mean by this? And I didn't do it. I just didn't do it. Well, the president's executive orders made all of us start thinking about it. Then about a year and a half ago, I published an op-ed in the New York Times in which I said that I thought that, with co-authored by Ilan Werman, who's a law professor at Minnesota, saying that I think the president's got a stronger case than people are thinking they have. And as a result of that, both of us got hit with a deluge of personal invective and all kinds of criticism. Yeah. Ilan got a lot worse than I got it. I essentially backed off because I still had not done all the work necessary to reach a settled opinion. But Ilan pursued forward. He went forward, and we were joined by another law professor named Kurt Lash, who normally I'm on the other side with, but he jumped into the fray. And Ilan talked about what was the common law of citizenship really? What was the background common law rule of citizenship actually? Not maybe what we've been told it is. And Kurt did a deep dive into the ratification of the 14th Amendment, but also the adoption of the Civil Rights Act of 1866, which informed the 14th Amendment. The Civil Rights Act itself had a citizenship clause in it by statute. And then the constitutional provision was supposed to implement what's in the statute. And as a result of their work, by the day before the oral argument or the day of the oral argument in the Supreme Court, I had a piece myself in the Wall Street Journal saying, I think the president has the stronger argument on the basis of the work done by Ilan Werman and Kurt Lash. Because that's where I came out on this, even though I myself have not done all the original work myself. By reading what is out there, I think they make the stronger argument.
And just for the viewer, what has the president asserted exactly? And if the court ultimately says you can proceed and this is actually the better interpretation or whatever, what does that mean?
Right. Well, I'm going to answer your question, but I'm also going to explain to you why the disagreement that befuddled me and befuddles everyone is not as stark as you might think. That there's a lot more agreement than disagreement, and we need to know what we agree about before we get to the disagreement. But before I do that, I'll just simply I do think I need to explain what the executive orders did. There were basically two features of them. And one, it said children who are born to persons who are not present legally in the United States do not get citizenship under the 14th Amendment.
Who are not present.
And who are illegally present, living in the country, illegally living in the country. They do not get birthrights. Their children do not automatically get citizenship.
So you hop the border pregnant, you give birth in Plano. Sorry, that's not good enough.
Well, there were two classes of people, and you need to keep them separate because they're being treated by the court separately, and maybe they should be treated separately. One are people who are somewhat permanently living here, who have children, but they're not here illegally. the so-called undocumented, that's what they call them, the illegal immigrants.
Yeah.
The other are people who are transients. They're passing through. They're just flying in, having a baby, and then flying out again with their baby. That baby was born here too. So you got the transients on the one hand, and then you've got the permanent residents or the people who are here indefinitely on the other hand. And the president's order applied to both groups and said the children of neither of these groups are citizens under the 14th Amendment.
Okay.
All right, so let's go back to the text of the 14th Amendment. The 14th Amendment says that any person born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states in which they reside. So you see, there is not one but two requirements under the 14th Amendment. Number one, you must be born in the United States. But number two, you must be subject to the jurisdiction of the United States. Two requirements, not one requirement. So anybody that just says, born in the United States, that's good enough, they're not telling you about the second requirement. Now, everyone that you got to be subject to the jurisdiction of the United States, not just born. If it was just born, they wouldn't have said the second thing. Right. They'd have just said, anybody born here is it. They didn't say that. Well, they said, and subject to jurisdiction thereof.
Well, and I mean, the implication there is the fact of stating that's pretty makes because one could say, well, if you're here, you're subject to the laws. Like if you're here, if you're a Canadian and you're here and you rob a liquor store, you're subject to the laws. But that's obvious, so you wouldn't need to state that.
Exactly. Boy, you're getting there. See, as soon as you start figuring out what everybody agrees about, the questions that seem so difficult to understand, they start to clarify. I'm not saying it's easy. It's still not easy, but it's easier. All right, so that's the first thing. And everybody who's serious on both sides, they agree. There are two requirements: born, birth, and subject to the jurisdiction of it. Nobody's contesting the born part. The whole debate is about what does subject to the jurisdiction mean. Okay, that's progress. Now let's focus on that. What does that mean? Here's something else everybody agrees on. Everybody agrees there were three groups of people that the authors of the 14th Amendment had in mind as people whose children do not automatically become citizens of the United States if they're born in the United States. Three groups. One is the children of diplomatic staff, ambassadors to the United States. If they have a child, they're not subject to the jurisdiction thereof. They're not citizens. Yep. The second group are citizens, offspring of members of an invading army that might be occupying part of the territory of the United States. If they get born in the United States, they're not citizens of the United States. And the third group, which turns out to be in some respects the most important one for understanding this, are Native Americans who are affiliated with a tribe, who are members of an Indian tribe. They have tribal affiliations. Their offsprings are not automatically citizens of the United States, even though they're born in the United States.
Yeah.
Everybody agrees. Everybody agrees these were the three exceptions or the three classes of people they had in mind. So what is the debate about? Some people might argue, very few, but some people might argue with they only meant those three classes and only those three classes. It's just those three classes. You'll hear a lot of people arguing like that. The more serious people on both sides, they won't argue like that because what they'll argue is, wait a second, they didn't adopt three classes. They said subject to the jurisdiction thereof. That's more general language. So the issue is, what is the principle that explains these three classes? And then, whatever that principle is, does it apply to children of illegals? And does it apply to children of transient people? By the way, the transient people here are here legally. They're just here temporarily. They're just passing through. They're not here illegally, but they're just that's why they're a separate class. You got the illegals on the one hand. They're not here, and then you got people who are here legally, but they come, they have a baby, they leave. Does the principle explaining the three exceptions or the three classes tell us anything about these? The whole debate is about what is the principle? What is that principle? And that's what the historical debate is about. That's not an easy debate to resolve. I'm not claiming that it is. But that at least is what you're debating. So the prevalent theory that I think ultimately the court sounds like they're moving towards to adopt, the conventional wisdom is it means like what you just said. If you commit a robbery here, you can be punished for it. But you've already sort of raised one of the things. Well, that doesn't seem like that would explain it, right? For one thing, Native Americans, if they committed a crime, even on a reservation, Congress could pass a law that reaches that. And they did pass laws that punish people for committing crimes, even on native reservations. So in a sense, Congress did have that power, that jurisdictional power, but they lacked something else. What was the something else that they lacked? And there's been various answers on the other side by Kurt Lash and by Ilan and by others on the other side. But maybe the best way of understanding is they lack these group of people lack allegiance to the United States, the way other people have, are presumed to have, and the United States has not agreed to protect them. They don't have a claim to the protection of the sovereign, and the sovereign doesn't have a claim to their obedience. They are just here, but they actually have obedience to other countries, the countries of origin, the countries they came from. In fact, that was how the Civil Rights Act of 1866 was worded. It said, persons born in the United States and not subject to any foreign power. That was the wording of the statute. Born in the United States and not subject to any foreign power. So why did they get rid of not subject to any foreign power and replace it with subject to the jurisdiction thereof? The answer that's been proposed, maybe it's wrong, but the object that's been proposed is the not subject to any foreign power would not clearly apply to Native Americans on reservations, because they are not subject to a foreign power exactly. They're subject to a domestic tribal power. And so they brought in the words to make sure that Native Americans were also included, in addition to people who were subject to a foreign power. And that's the reason why if you come in and you're subject to a foreign power, you're not subject to the jurisdiction. You're not subject to what they call the full jurisdiction of the United States. So, for example, your children could not be drafted into the U.S. Army if you happen to be here as a transient and give birth to somebody. Can you imagine that? If somebody gives birth here and then they go back and then the U.S. come out and they just say, "Okay, you got to serve in the U.S. Army now." Well, that's what the Tsar was doing to people in the Pale, trying to get everybody drafted into the Army. People got away from that. Anyway, the point here, I got myself a little off on a tangent here. The point here is the debate is all about the principle. Now, you asked me what the Supreme Court is likely to do. Yeah. Generally speaking, the only thing anybody ever asks me about from the press, not podcasters, but from the press is, tell me what the court's going to do. That's all they're ever interested in. And in the Raich case, the medical marijuana case, I learned that I basically adopted the principle that I never predict what the court is going to do. And one reason I adopted it for that case is if I had to give my honest opinion, I would have thought we're going to lose. And I'm not going to tell people that. So I'm going to say I never give opinions. And here, I don't know what the court will be doing, but I listened to oral argument, and it sure sounds to me like they're either going to punt, but it's very hard to punt this one, or they're going to just adopt the conventional wisdom. And one of the reasons I think for that would explain that if they do that is that the good work that's been done on the other side was extremely recent. The work by Ilan Werman, the work by Kurt Lash, and there's others besides those two, but they were the principal. They've all been done within the last year. And it didn't have time to resonate, to percolate, to be fully tested by other people's criticisms of that work. And it's just too soon to expect justices who were raised with one idea to completely reverse course and go with this new idea, this other idea, which is really an old idea, but one that got lost like a bunch of other parts of our Constitution have gotten lost. And so for that reason, I wouldn't be surprised if the court adopted the conventional wisdom.
And that conventional wisdom would be in opposition to what President Trump is asserting with the EOs.
Because the conventional wisdom is if you're not in those three classes, then you're good to go.
One of the things that I have probably personally changed on the most as a libertarian type person, libertarian minded, is the scope of immigration. If you asked me 5 years ago, where are you at on immigration? I would have said I'm basically open borders. And that in the kind of pre-1924 US sense, like, hey, my ancestors came in 1921 from southern Italy. We're treated like Southern Italians and everybody else was treated when you first get here, like, oh, you're a bunch of crooks and criminals and off to the coal mines for you. But that's what made America. We're a nation of immigrants, right? Like I do believe we are in part somewhat a nation of immigrants up to a point. That story's more complicated than it gets told. We're a nation of immigrants, except really between 1924 and 1965, where immigration more or less was almost totally shut down. What has shifted my thinking is that, and made me more restrictionist than I used to be, though probably still less restrictionist than your average Trump voter, is there sure are a lot of people that come here and just straight up tell you they hate the country, including the current mayor of New York City, who arrived here in 2018 and says he hates the country. Like literally, his ideology hates the country. And like the constitutional principles, everything about it. And what kind of entity would want to welcome people in that hate it? That just doesn't seem like it makes any sense to me. Like, how could you continue to have this thing that's distinctively America with our constitutional principles that protect all of us? If you're bringing in people who, you mentioned sort of you don't want to have invading armies, it's like, well, I don't know, what constitutes an invading army? And I'm not talking about most of the Mexican guys who are coming here building houses. I'm a lot more uncomfortable, and I'll just be super transparent about it, like particularly Islamic immigration, where you've got a religious ideology that in its core precepts doesn't seem to be compatible with American constitutional order. Like Sharia law is not compatible with the U.S. Constitution. Again, I do my little thing where I monologue a little bit, give you some stuff to react to. But have I just become like a raging hate monger? What do you think about? Where are you at? How do you assess sort of the changing face of this issue more broadly and as it pertains to liberty and being an American?
You are a real-world libertarian, and that is what my book is going to be about. And part 4 of my book is the title of part 4 is Libertarian Nationalism. And the first chapter about libertarian nationalism is about proper self-defense. When is military action warranted and when is not warranted? Let's not get into that. We don't have enough time to talk about that.
Sure.
The next chapter after that is about immigration. And I do think the government's first duty, this is actually the Equal Protection Clause, the first duty of government is to protect the rights of its citizens. It has no general warrant to protect the rights of all people in the world. Those people have natural rights, but the government that's here only exists to protect the rights of its citizens. Part of it is obvious. You should go out and use police to protect your rights. That's what the southern states were not doing, which is why the 14th Amendment got enacted with an Equal Protection Clause. But the other thing is to decide who gets to come in and who doesn't who gets to reside here permanently and who does not get to reside here permanently. And it may very well be that there might be some freedom of travel that people can travel through the United States or to and come and go, but not settle here. And a civil society is a membership society. You have membership in it. That's what we just were talking about. What does it mean to be a citizen of the United States? It means you're the member of this particular civil society, not another one, not a foreign power, but this one. And the government of this one has a duty to protect the rights of the people who comprise it here, the rights of the people it represents here. And if that means keeping people from other countries from coming here and undermining the rights and liberties of Americans, this is the first duty of government. And it's as big a duty of government as to protect from literal armed invasion, which is also a danger and which is what the other chapter is about. But it also protects us from these other sorts of things. And that is the duty of government. Nobody has a right to come and live here permanently, just as we don't have a right. And if you try to exercise it, you'd soon find you have no right to settle in France permanently. You have no right to settle anywhere in Europe or in Latin America. Well, there may be a couple places in Latin America. There's some exceptions. But by and large, you can't go Americans can't go elsewhere and settle without the permission of their governments, and other people can't come here. But the criteria of the restriction has to be the one you are reaching for, and that is the criteria of restriction has to be connected to protecting the rights and liberties of Americans. And that would include screening people to see how committed they might be to the rights and principles of American citizenship. And if they're not, sorry, that don't come here, go somewhere else that you think is better.
I mean, there's a story in the news right now that to some extent brings these two worlds together. And it's
Okay, can I say one more thing?
Please.
But and that is that what I've just said is considered hateful by libertarians associated with the Cato Institute, who are my friends and who I've long had associations with, and other people. Reason Magazine, again, my friends. I attend the dinner every year they have at Freedom Fest. I like what they do, but there's this libertarian catechism that would basically condemn what I just said as being unlibertarian. And the reason why I'm writing a book about libertarianism is because I want to argue, explain exactly why this is what libertarianism in the real world needs to look like. And then give the reasons and own up to the limitations and the problems that would arise. But I do think a book like this it's time for a book like this for people like you, for people like my brother who won't call himself a libertarian anymore, and others I know who don't call themselves libertarians anymore, precisely because of this issue and other issues like it. I think what they need is a better libertarianism, and that's what I'm in the process of trying to produce.
Yeah, I think that in so many respects, I feel like we are at a interregnum, grappling with a bunch of things at the same time. There's not one we conversation, right? So I say that kind of stuff with a lot of trepidation. But one of the things that is going on, it's certainly going on in the broader public intellectual space outside of traditional think tanks, but to some extent traditional think tanks too, is what's called post-liberalism. This look back, this sort of sense, and I feel like Europe, it's even more acute in Europe, where the immigration issues are much more pronounced, where there's a sense in which the whole of the so-called liberal project, and I say liberal in a way that's broader than American left, but it includes those of us, I consider myself broadly a classical liberal, Adam Smith, John Stuart Mill, freedom of free trade, free travel, a global cosmopolitan society that's sort of politely governed by institutions like the United Nations, sort of Wilsonian, that all, there's an element of Smith and Wilson, of Smith and Mill, that you can see there's a tiny bit that survives into the Woodrow Wilson progressive technocrat zone, although most of it him and his hate. But you have this thing happening now. I mean, I'll bring it back to the story that's in the news as we sit here. A young man in the UK was just stabbed to death by a I think a sheikh. I don't know if he's from Pakistan. I'm not sure what. But basically, the cops show up at this, show up to this scene where this young man has been stabbed. And the person of color, let's say, tells the cops he was yelling racist things at me, which in America, of course, is not a crime. It's just rude. And the cops proceed to ignore this young man's pleading that he's been stabbed and arrest him for the hurty words crime, to which the UK now arrests over 12,000 people a year. And Twitter is all ablaze in this for good reason, because it's worse than George Floyd in terms of an I can't breathe moment with cops ignoring you and letting you die. And it's not self-induced like fentanyl. It's being stabbed by it's being stabbed. And so why do I bring that up? It's in some ways it brings together the things we've talked about. You have crime in the streets. You have what essentially is murder. You have a police that has basically decided it's more important to police hurty words from brown people than take seriously that somebody was just stabbed in front of you, and actually really not let them die in your presence and under your control since they cuffed him. And the whole politically active world on Twitter and beyond looks at this and says, behold the death of the liberal order. This is what empathy has wrought. We invite a bunch of people into our societies that hate it. We convince ourselves that we should also be with them and hate ourselves. And what do you know? They kill us. Now, it's really hard. It's really hard as a classical liberal-minded person and a Christian and an American to grapple with the implications of all of that. But I don't think we can just push it aside.
Well, It may not surprise you to know that the chapter I am currently writing, the one I'm in the middle of writing, is about post-liberalism. Because now the book is more or less done. I mean, I've got to the end of it, and now I'm adding a thing here and I'm adding a thing there that I think is mostly replying to opponents of the view I'm talking about. And the one chapter that I am in the middle of writing is about post-liberalism. So I've had a chance to review the work of Patrick Deneen and review the work. I've already know the work of Adrian Vermeule. And I already know the work of Yoram Hazony. And so I know a lot of what these post-liberals are saying. And let me make 2 points about it. One is they're actually pointing to valid problems. The problems that they're talking about are real and should not be dismissed. And what status quo libertarians do is just dismiss the whole concern as being nothing. They're whistling past the graveyard. They just refuse to allow that there's any such problem to exist. And what you've just described is a problem. So I think they're pointing to a problem. But here's where I think they actually do an injustice. There is a word called liberalism. It once had a particular kind of meaning. It's the meaning I'm reviving. It's the meaning that I'm going back to in talking about libertarianism for the real world. Those people, the Republicans who were dealing with resistance in the South, they were real people. They were not intellectual. They were not law professors, although Charles Sumner had been a law professor at Harvard Law School before he drafted the Civil Rights Act of 1875. Anyway, the point here is that they were operating in the real world. They had a real problem they were trying to address. And they did so, I believe, consistent with what liberal principles would require. That's with respect to that problem. With respect to other problems that hadn't arisen, that's another matter. But there's that liberalism. And then you have, as you just pointed out, the progressives who came along and they took over the name liberal. They gutted it. They wore it as a skin suit. And now they demand respect for it. And that's what happened. That's David Berg on Twitter at X is his famous tweet. And so that is what we face. And so, but what the post-liberals insist on doing is collapsing one into the other because the word is the same. And I have personally appealed to at least one of them, I'm not going to say who, to stop doing that. Because it's misleading. It's confusing. When you say liberals are doing this, I want to know what liberals you're talking about. Are you talking about Wilsonians who actually hate the country?
Yeah.
Or are you talking about classical liberals who believed in natural rights, who believed in natural law, and who ardently defended our freedoms on that basis and believed in the regulation of liberty for the common good? They believed in all of these things. They were liberals too, but not these guys. And so the argument that Deneen wants to make is that there's two pincers. There's the pincer from the progressive left, and they've got their problem. Then there's the liberals coming in, and they've got their problem. And you see what you've got is the subject of liberalism. And I just want to say that second pincer is not really real. The second pincer is really the first principle, the pincer using the label liberal to describe what they want, which is illiberal. And so the book I want to write, and so the treatment I'm giving of this post-liberalism is that the liberalism I describe in my book, based on natural law, natural rights, the role of institutional competence, etc., that's a liberalism that takes seriously the problems that Deneen and the others are rightly concerned about, or are rightly voicing. I should say the people who like Deneen and who like Vermeule and who like Hazony, they're rightly concerned about. I just think there's a liberal response to what's going on in this country and in the world. This citizen of the world business is what libertarian nationalism should speak against. We are not citizens of the world. We are citizens of our country, and our governments owe us a duty and part of protection, both from internal threats, the crime issues we've been talking about, from external threats, which would be military, and also from cultural effects, external threats of people coming in who don't share our values and don't share our culture. And so this is something libertarianism and liberalism generally needs to take on board and take seriously. And I think it can. I think we do have the resources for doing it. And so I want to both grant that the problem is real, and some of what they say about the problem is also valid. But the solution to the problem, which is a more authoritarian promulgation of either ecclesiastical law, imposing it on us, or on just imposing morality generally, that's not the way to go. We've tried that too. Liberalism was the answer to that problem. And believe me, many, many people died at the hands of that kind of illiberalism. But the liberalism we now have, which is now they call themselves progressives, helpfully for you and me, so we don't have to call them liberals if we don't want to. We can just call them progressives.
Yeah.
They're getting, they are not getting the blame they deserve from the post-liberals. And classical liberals are getting blame they don't deserve because they simply get grouped by association because of the name liberal.
To what extent is the fundamental problems that might even link people who are more classical liberal with the progressives, utopianism, like the sense that what one should strive for in this world is utopia, and that it's achievable enough that I can make it my North Star, rather than grappling with what, as a Catholic, as a Christian, I would say is like the fallen nature of man. That we'll never have that. We're fallen. There's all kinds of problems. There's original sin. There's a bunch of stuff. Even if you don't believe any of that, just look around. It's a messy place. Do you think that might be one of the things, because that's certainly the thing I've become most sensitive to, is when something smacks of being utopian, my back stiffens and I'm like, I think you might be acting like a child and concocting imaginary worlds for yourself.
Well, I think you'll be pleased to hear that's how I that's kind of how I characterize the status quo libertarians that you think of as libertarian today. I don't call them utopians because utopians would require a basic change in human nature for it to work, and they're not advocating for that. I call them ideal world libertarians, and they basically are developing a model. And I did this too. I was an ideal world libertarian. The book, The Structure of Liberty, my first book, is an ideal world libertarian book about what would happen in an ideal world if you fully implemented libertarian principles, what that would be like. I think that's a valuable exercise. However, it's a mistake. It's a fatal mistake to think that you can move the world we have, the real world of competing nation states, into a more libertarian direction by taking pieces from ideal theory and just plugging it in willy-nilly into the real world. Maybe one of the pieces of ideal theory is everybody should be able to go where they want the way you can within the United States go where you want. Maybe ideally we want a world like that. But if you take that policy by itself and you plug it into the real world of 180-some nation states competing with each other and with different cultures and different values, that policy is not going to work in this world, even if it would have worked in your ideal world. And so that's the reason why the subtitle of the book is Libertarianism for the Real World. That's what we need. Those first principles, they're not going to necessarily be the same first principles as the ideal world needs. It'll be informed by that ideal world, but you just don't transfer it jot and tittle. And so, at any rate, I agree with you. I think we've covered an awful lot of ground in the past couple hours. I think it's been
the hardest thing about the moment we're in when it comes to this like reevaluation of all the things is that knowing what's the baby and what's the bathwater is hard and it's dangerous. And I think you're right. I think that the sense that there's problems, therefore government, is about being skeptical of that answer is I think one of the most healthy things of a libertarian mindset you can have. Here's a problem, therefore monopolize centralized power as the solution. It's not impossible that maybe that's the answer, but it's almost certainly not. Whether it's culture, religion, borders, that's a good case, kind of by definition. But so as we come to a close, when you think about liberty on this 250th of our country, how do you think? How are you evolving? How do you think about the healthy impulse towards liberty that is uniquely American, because it very much is, it's particularly American, this obsession with freedom and liberty in the way we do and the way we have through this conversation?
Well, it's an obsession with individual liberty. And as the post-liberals want to tell us, that's not the same thing as the liberty of the ancients. The liberty of the ancients was a more constrained form of liberty. It was the liberty of people to govern themselves. Our commitment has been to the individual inalienable rights of life, liberty, and the pursuit of happiness. These were rights that belong to individuals. Living in society with others, to be sure, and that's very important. It's part of the story. But these are the rights of individuals. And what's interesting about that formulation, and it was not the canonical formulation, there are other formulations that were in state constitutions that mention property, for example. But this was the right to life and liberty and the pursuit of happiness, which is not the guarantee of being happy. What was the pursuit of happiness a reference to? I believe it was the reference to human flourishing according to the natural law, which means we each have our natures, and in order to actualize the potential that we have as human beings, we need to act virtuously, and we need to avoid vice. We need to operate in the golden mean between extremes, and that is what the founders thought, and that's what the pursuit of happiness was about. Not the guarantee of happiness. Happiness was not sitting in a warm bath and having sensory pleasures. That was not what happiness was. Happiness was an activity of life, living a good life by being a good person. One of the things I told people after I wrote A Life for Liberty is that as a guide to living, you should live your life as though you were going to write a memoir about it. First of all, I think everybody should try to write a memoir for their family. You don't have to publish it. It would be valuable. I wish I had memoirs of my ancestors and what they were going through. But besides that, you should live your life, if you're young, as though you're going to write a memoir. Why would that be? Because when you look back on your life, as I did when I wrote my book, there's the stuff I regret, and there's the stuff that I did that I'm proud of. And I try to put it all in my books. Both Felony Review has the mistakes I made as a lawyer, not just the things I did right. And living your life as though you're going to write a memoir about it means you want to be proud of it. And that will have you avoid behavior that you wouldn't be proud of, and pursue the behavior you would be proud of. And that's really what living the good life is about. And it's the duty of government we leave the state of nature and we enter into civil society so that we have a government that will protect the jurisdiction or rights we have within which we get to pursue happiness. That is the American creed. That is also the American culture. Creed and culture are not opposed to each other. They must reinforce each other. And if you actually threaten the culture, you're going to lose the creed. So you need both creed and culture, and that's what I think a libertarianism for the real world must come to grips with.
That's a great place to close. It's a really provocative and also very realistic thought. Creed and culture, the way that those two interact. Randy, I always learn something speaking to you. Your books, The Original Meaning of the 14th Amendment, your new one, Felony Review. It was a pleasure to continue our conversation. I look forward to your next one and where it shakes out on a libertarianism for the real world. Thanks for being back on Dad Saves America.
Next time in Las Vegas.
But indoors.
Indoors.
Sounds good.